Welcome back to Savannah Car and Truck Accident Law with Andy Conn. I'm Brooke, sitting down with Andy Conn of Conn Law Firm in Savannah, Georgia. Today is episode 6, and we are answering one question every family that suspects medical malpractice in Georgia asks. What is the case really worth? We're walking through what makes a medical mistake rise to the level of malpractice, why Georgia stands out as the state with no cap on non-economic damages, how the damages actually get calculated, the fact patterns that carry the highest values, how an expert proves the case, and the Georgia filing rules, the OCGA 9119.1 expert affidavit, and the deadlines that can decide a case before it ever reaches a jury in Chatham County. So our first question today, a patient had a bad outcome and cannot tell whether it was negligence or just an unavoidable complication. In plain terms, what makes a medical mistake rise to the level of malpractice?
Hey, Brooke, thanks. Yeah, that's always the most important question. And it's not always an easy question to answer. Sometimes you can answer them fairly quickly, but sometimes it takes extensive expert review and things of that nature. But the simplest way to explain it would be that sometimes bad things just happen, and it's not because a doctor or a nurse or a medical professional did something wrong. To sustain a medical malpractice case, they have to breach the standard of care here in Georgia and in most states for that matter. And what that means is that they don't act the way that doctors and nurses should under those circumstances. Another thing is you have to not only prove that somebody did something negligent or breached the standard of care, but further that what they did wrong actually was the cause of what happened to you. And so a lot of times it requires not only just the expert who says this doctor did something wrong, but then a separate expert who could come in and say, and that thing that they did wrong led to the catastrophic injury or unfortunately, the death.
Yeah, I mean, when something bad happens, it's always super easy to blame it on another person. But it sounds like it's very important to make sure you get all your facts in order before turning to malpractice. A patient keeps hearing the phrase standard of care and doesn't know what it means or how anyone proves it. What is the standard of care, and how is it proven a doctor fell below it?
Yeah. So the standard of care in the medical malpractice sense is just a fancy way of saying that a doctor or a nurse was negligent. If you're negligent in a car wreck case, it means you ran a stop sign or you were driving too fast. In the medical malpractice context, it means that a doctor did something or a nurse did something that generally should not be done in a particular circumstance. So in Georgia, you have to have a medical expert in the same field to be able to sign an affidavit, to be able to even bring a lawsuit in Georgia. And if you have a case against, say, an ER physician, then you have to hire an ER physician who has to determine that the ER physician that provided your care fell below the standard of care.
Okay, that's super interesting and sounds like a good method to make sure that the doctor actually did fall beneath the standard of care, considering that person does the job themselves. I appreciate you sharing that. A family has read the most states limit pain and suffering awards and want to know why Georgia is different. Why does Georgia stand out as a state with no cap on non-economic damages?
I love that question. There's a lot of reasons why Georgia is the way that it is, but the main reason is that Georgians and our elected officials, through people who vote for them, have decided that we don't want to put a cap on somebody's life. We don't want to put a cap on someone's pain and suffering. And we trust the jury system, right? It's in the Constitution of the United States. The Seventh Amendment is the right to trial by jury. And to put a cap on what a jury, 12 strangers who, by the way, in Georgia have to unanimously decide that someone is able to recover a certain amount. But in Georgia, to take that away from the 12 members of the jury would be to violate the United States Constitution. And in Georgia, fortunately, we've decided as a community that someone's life is valuable. The value of someone's pain and suffering is also valuable. And you shouldn't cap something that's only going to benefit insurance companies and large corporations.
Absolutely. A listener wants the story behind the rule that makes Georgia different. How did the Georgia Supreme Court strike down the malpractice damages cap?
Yeah, I said that the elected officials, by and large, have not capped medical malpractice damages in the last 20 years. They did try to do that back in, I believe it was 2005. They passed a law that said that there's a cap of $350,000. I've got a case right now, 8-month-old little boy. His mom brought him to an emergency room and to a doctor's office 4 days in a row, saying that there was something wrong with her child. Nobody took her seriously. And this poor kid passed away due to the negligence of several. And if that law was still in place today, then the folks who voted for that back in 2005 would say that 8-month-old little boy's life was worth $350,000. Fortunately, as you mentioned, the Nestlehutt decision, our Supreme Court did the right thing. And they said that is unconstitutional, that you actually have to pass a constitutional amendment to have a cap on damage, because the right to trial by jury is one that you can't pass with just a majority vote. You actually have to do that with a constitutional amendment, which I believe requires 2/3 vote.
Okay.
And fortunately, I don't always agree with our appellate courts. I'm sure they won't be surprised to hear that, but I think they do. We have a very good appellate court system that I think is trying to get it right. And in that particular occasion, definitely did get it right.
I appreciate you sharing the real life story. It puts things in perspective for the listeners here. A listener has heard about the 2025 Georgia Tort Reform Bill and is asking whether it changes the no cap rule. We talked about this a little bit, but what an SB 68 and how could it reshape malpractice valuation in Georgia?
The SB 68 stuff was really more geared, for the most part, towards auto collision stuff. There was nothing specific in the bill that pertained to medical malpractice. There are some things that do have implications for medical malpractice claims. The way that you try your case, there's something called that at times is required now, which means you have to try the did the doctor do something wrong phase first. And if you win that, then you go to the how much is the claim worth portion with the jury. But there wasn't anything specific to medical malpractice. There are other things like the collateral source rule was changed in SB 68. And what that means is if you have paid insurance premiums your whole life, let's say 20, 30 years, you used to get the benefit of that. And you would be able to introduce to a jury the amount of your medical bills, even though that's reduced because you've been responsible, you've been paying insurance premiums all this time, and you get the benefit of the reduction of those contracts with your health insurer. Now, the insurance lobby did a very good job in taking away Georgians' rights and saying that now actually they get to show that the reduction of what is paid, actually paid, not just the medical bill amount. So what they're saying is essentially, if you're less responsible and you're uninsured, you get to show the full value of your medical bill to a jury. But if you've paid premiums for 30 years, you actually get a reduction that a jury sees, which can affect medical malpractice cases. It can affect a lot of other types of cases as well. Frankly, the types of cases that we work on at Conn Law, typically medical bills, the amount of medical bills is not something we really anchor our case to. That's not typically the most important thing. The most important thing is, what is life worth? What is pain worth? Those are the sorts of things that I like to talk to a jury about. So in my personal practice, has it made a significant change? Probably not, but it does have some wide-ranging implications for some cases.
So once the framework and the no cap rule are clear, the next question is the one every family really wants answered. What is the case actually worth? A family is staring at hospital bills and wants to understand the hard number side of the claim. What are economic damages in malpractice case and how are they calculated?
Yeah, so we go back to first of all, there's economic damages and there's non-economic damages. The economic damage things are the tangible things, like we talked about a second ago, medical bills that you've incurred. That's an economic damage. Or if you've been off of work and you've lost wages, that's an economic damage. When we use life care planners to determine what your future medical costs are going to be, that's an economic damage. Then we have the non-economic damage side, which is the things that are less tangible, that are frankly harder to determine how much it's worth. So what is pain worth? That's non-economic. What is suffering worth? That's non-economic. What is the value of somebody's life who passes away in a wrongful death case. That's non-economic. So evaluating what a case is worth, we factor in all of these different things. And I have to have this conversation with my clients all the time that unfortunately, the question we have to decide it's not what is the value of a life or what is the value of the
Right.
pain, but what is the value of the case given a number of different factors that go into that equation.
Yeah. So when it comes to the economic side, they are looking at both the past, like economic damages, as well as the future stuff. How do they figure that out?
Well, the past is pretty easy because there's a bill that's out there, and there are experts on the defense side where they'll try to challenge those at time, but it's usually pretty easy. If
Okay.
you incurred $100 in medical bills, then you have $100 in
Right.
medical bills as your past. But if let's say you've been recommended for a surgery
Uh-huh.
because of what happened to you, and you have a doctor or maybe a professional with the hospital who's proposed this surgery that'll come in and say, this surgery is going to cost $100,000. That would be a future medical expense,
Okay.
a future economic damage that you can still recover for in Georgia if a jury believes that's something that is related to your claim and is reasonable.
Okay, that totally makes sense. Now, we talked a little bit about non economic damages already, but a family is being told that the biggest part of the case may be the part with no receipt attached. What do non economic damages cover when there is no cap to limit them?
When there's no cap, a jury, the standard is it's the decision of the enlightened conscience of an impartial jury. That's a fancy way of saying there are 12 members of a jury who listen to the evidence, who hear
Okay.
from people who knew the person if it's a death case, or people who still know the person if it's an injury case, who can talk about what this person was like before and what this person was like after. And so without caps, we trust 12 jurors who, by the way, again, have to come to a unanimous decision. We trust them to make that decision. And it's a really hard one for them to make. It's a really hard one for us as lawyers
Right.
to even quantify and try to put a number on as well. But it's frankly, it's what the case is. That's where the real value is because medical expenses, I get it. They ain't cheap and we don't want to pay them, but that's not when somebody thinks about their harm and what was lost, they're not thinking about the medical bills. They're thinking about what they've missed out, the grandkid they can't pick up
Right.
or the loved one they'll no longer see. And that's really where the true quote unquote value of a case to me really is.
Yeah, for sure. Life is very valuable and quality of life as well.
Mhm.
A family is trying to understand how anyone puts a number on a lifetime of care that has not happened yet. How are future medical costs and life care needs valued?
Yeah, there's a number of different ways to do them. But one thing we've mentioned on this podcast before, probably the best way to do that is to get a professional, to get an expert involved, because you have to have evidence that you present
Right.
to a jury. And what a lawyer says doesn't constitute evidence. So oftentimes you'll hire a life care planner, someone who's actually qualified and credentialed to work with your doctors that you're treating with currently, potential future doctors, and then they do an analysis that actually demonstrates what your future needs are from a medical perspective, but for also other types of needs. If you need a wheelchair, how long does a wheelchair last? When will you get your next wheelchair? Perhaps if you are unfortunately paralyzed due to some form of doctor negligence, you might need to retrofit your house with bars, with
Right.
ramps, different things like that. A life care planner who's really good goes through all of those things to determine those future costs into for the rest of your life, what that's going to look like.
Sounds like the life care planner is a very valuable asset in some of these cases to take advantage of.
Absolutely. Yeah.
A patient who can no longer work the way they did wants to know how that loss gets valued. How is lost earning capacity factored into malpractice claims?
Yeah, just like with any other case. And I think that's a good point you make, by the way. There's a difference between lost wages, which again is that what have I already not made that I would have made? Lost earning capacity is a different thing. It's not only what you are going to continue to make in the future, but if you were on a trajectory, say, to get promotions and have additional benefits and salaries in the future, you can actually recover for that too. So even if you're making, say you're making $50,000 a year today, you don't have to just rely on that's what you're going to make for the rest of your life. If you're making $50,000 at 30 years old, it stands to reason you're probably going to make more than that when you're 40 years old and more than that when you're 50 years old. So there's a way, and you can use an economist is one way to do that, and use other evidence to show this person was on a trajectory to actually earn more over the course of their life.
It's a really good point. Not something that I had ever really thought about in these cases is the fact that people's wages change over time. So
Yeah.
a family wants to understand why two malpractice cases with the same mistake can be worth wildly different amounts. How does the severity of the harm drive the overall case value?
It's essential because, listen, the same doctor can mess up in the same exact way, fall below that standard of care that we were talking about. And sometimes that leads to really bad outcomes. And sometimes people heal, they get better, or maybe whatever the thing it was that the doctor didn't lead to a bad outcome. I'll give you a good example. In stroke misdiagnoses, sometimes when you misdiagnose a stroke, the blood to the brain is cut off for long enough period of time where you have a catastrophic injury where you either potentially pass away or you're severely mentally incapacitated for the rest of your life. Sometimes people get lucky. Even if you misdiagnose the stroke, the clot could actually break up on its own. And even though that doctor committed malpractice by missing it, the patient might actually recover and walk out of the hospital. And so the difference between someone who had a bad day but recovered immediately and didn't have any permanent issues versus someone who either passed away or can no longer perform the normal daily functions that they could before, those are very different types of cases. And frankly, in the medical malpractice context, the latter case of the person who wasn't severely injured probably isn't a case because medical malpractice cases are so expensive to litigate.
Absolutely. Knowing the categories is one thing. The fact pattern, what actually went wrong, is what pushes a case to the top of the value range.
Right.
A family whose child was injured during delivery wants to understand why these cases are treated as among the most serious. When a baby is harmed at birth in Savannah, how do these cases get valued?
Yeah, obviously, children, unborn and just born children, are among the most vulnerable members of our population and society. And to think that what's supposed to be the happiest day, certainly the happiest day of my life, 3 times with my 3 kids, the births, they went well and they were happy, healthy children from day one, and they continue to be. So to imagine that day being now one of the worst days of your life, if a child dies during childbirth, I can't even imagine as a parent what that must be like. And I've had clients who have experienced that. And sometimes you have injuries where a child maybe has cerebral palsy or some permanent brain injury or some sort of other permanent injury. And it can happen very easily in the delivery room. And there are a number of protocols in place that, if followed, typically it should not happen. But typically when you have something like that, the reason the cases are quote unquote so valuable is because we value children who are most vulnerable higher than we do adults. If the same injury happens to me as happens to a 1-year-old, they're going to value the 1-year-old's case higher because we can empathize more with a 1-year-old, especially given that the vulnerability and their lack of any ability to defend themselves.
Yeah, they can't advocate for themselves. They can't
Right.
speak, so they're very vulnerable.
Yeah.
A patient whose diagnosis came too late wants to know whether that delay is something a case can be built on. How does a missed or delayed diagnosis become a malpractice case?
Yeah, well, just like with anything else, you have to not only prove that the doctor actually misdiagnosed it, you have to prove that there were signs that should have been caught that weren't caught. The hard part about the misdiagnosis cases at times is sometimes, even when somebody delays in diagnosing something, that doesn't necessarily mean that's the reason that you had the bad outcome. I've had a case before where, I worked this case up, had several experts involved, and a gentleman who unfortunately contracted cancer. And they took a year, longer than they should have, to diagnose his cancer. And I had several different doctors who agreed that the doctors who treated him did something wrong. They fell below the standard of care. And the last expert I hired was an oncologist to determine if the delay is what actually led to this poor gentleman passing away. And unfortunately, in that case, that oncologist decided no, this type of cancer, the stage it was at when they missed it, was going to kill him. And so
Okay.
even though they messed up for a year, it wasn't going to change the outcome. Now, I've had other cases. I've had stroke cases, for instance, where they delay in diagnosing a stroke, where it did have a monumental outcome, where if they would have caught it early, this person would have probably walked out of the hospital normal. Instead, this person is severely and forever cognitively impaired. And the difference sometimes between what is a viable misdiagnosis case versus one that's not is razor thin.
Yeah, for sure. Now, a patient harmed during surgery wants to understand what kind of surgical mistake actually supports a claim. What counts as surgical error and who is responsible for a never event?
Yeah. So, I mean, listen, those are really hard cases at times because there's a lot of known risks going into surgery, right? And you get to the hospital and they have that long list of things and you don't know what any of it means, but they have you sign on the dotted line of what the known risks are. So sometimes it's really hard to parse through, is this something that was known that could happen? And even if it was known that it could happen, that doesn't necessarily mean there's not a case, because
Right.
just because it's known, if a doctor does something that they shouldn't have during surgery that led to the known thing, you still could have a case.
Right.
Sometimes proving that, though, is very difficult depending on the type of surgery. Obviously, there are all types of surgery cases. There are back surgeries, there's kidney removal surgeries, there's knee surgeries. So each case is going to be very different from one another. But finding the difference between what is a known risk or what is actually malpractice, you really have to have a seasoned trial attorney who does medical malpractice cases to be able to help you make that determination.
Curious, what is the never event? That's something that I've never heard of before.
Well, never admit is exactly what it sounds like. It's something that should never happen in a surgery. So, like I said earlier, it's hard to tell if the doctor nicked or did something like that's not a never event. A
Right.
never event is you've got a sponge left in you after your surgery. That is not supposed to happen. And at times that can lead to really catastrophic events. It can lead to infections and sepsis. But there are some things that are a little bit easier to prove that should never, ever happen in surgeries. Another one is you come in for an amputation of your left leg and you wake up and your right leg is gone.
Oh,
That's a never event.
okay. Yeah. Now I definitely understand. I've seen
Yeah,
that in Grey's Anatomy before. So
that's right.
I appreciate the
Yeah.
explanation. A patient harmed by the wrong drug or dose wants to know whether that is its own kind of case. Can a medication or anesthesia error support a malpractice claim?
Yeah, like with everything else, it depends. And it requires thorough review by a qualified medical malpractice attorney and likely experts. But yes, if you are prescribed too much of a medication, especially if it's in a hospital setting where you're not in control, you're not the one taking the pill, they're infusing it intravenously through your arm, and they give you the wrong type of medicine, or maybe they add a zero, you're supposed to get 10 cc's and you get 100 cc's. Absolutely, those are viable claims that shouldn't happen. And sometimes it really can come down to something as simple as a clerical error that leads to you having a really bad outcome and sometimes even death.
Super scary. A
Yeah.
patient who was never told about a risk that materialized wants to know whether that it is its own claim. When does a lack of informed consent create a separate claim?
Yeah, well, that's a good question. And those are, if I'm being honest, those are very difficult cases because
Okay.
sometimes it comes down to a he said, she said thing. That's why they try to get you to sign the informed consent documents so that they have something in writing. But sometimes they don't have it in writing. And it comes down to whether you believe that the doctor actually informed me of this risk or not. And so, what I'd say with those is if you're very credible and you present well, a jury is going to like you and trust you, then there's a higher likelihood of winning those types of cases. But they are among the more difficult when it comes to medical malpractice cases.
Of course. A strong fact pattern still has to be proven. And in Georgia, the proof and the filing rules decide whether a case ever reaches a jury. A patient wants to understand why so much of a malpractice case rides on expert witness. How does an expert establish both the breach and the harm it has caused?
Yeah. And what you're referring to is there's a gatekeeping function where to even file a medical malpractice lawsuit in Georgia, you have to actually have an expert sign an affidavit that says that this is a meritorious claim to be able to file it. You don't have to do that in car wreck cases. You don't have to do that typically in product liability cases, but you do in medicine. And there's a good reason for that, right? A layperson can't necessarily say that a doctor did something wrong. That's not something that you know by your life experiences.
Right.
So having a qualified expert to say that the doctor did something wrong is an understandable hurdle that you have to get through to be able to file a medical malpractice lawsuit. But you also want an expert involved because these things are complicated. And having somebody that your lawyer can rely on to help understand the case and how this awful thing happened to you is going to be really important. But also when you do, if you're lucky enough to get to a jury trial, when you go to that jury trial, you want an educator.
Right.
You want your expert to be able to explain why the thing that happened and why the doctor or the nurse was the reason for that bad thing happening.
It sounds like if there's no expert, there's really no case. That expert's super, super important in being able to prove your case or even file your case.
I have conversations all the time where it seems to me that it's a case, and I talk to an expert, and an expert says no for X, Y, and Z reason. Typically, that's where we stop our analysis because we know we can't file a case. Although there's one case that I pushed back. I hired a second expert, and he disagreed with the first expert. So experts also can disagree with each other at times. And so it's important that you got somebody who's going to be an advocate. And when it is necessary, get a second expert to talk about your case.
That second opinion is always important.
Yeah.
A patient is being told the mistake is clear, but causation is the real fight. What is medical causation and why is it the hardest part to prove?
Yeah, it certainly can be the hardest part to prove. Not always, but certainly can be a very difficult thing to prove. And here's why. We think we know a lot about medicine, but they still call it the practice of medicine for a reason because there's still a lot of unknowns and there's a lot of moving parts with the body. It's not like a mechanical process where you can download something from a vehicle and understand what broke down. With the body, we have to use a lot of physical evidence and kind of interpret what that means. And so causation can be very difficult at times, even if you know a doctor messed up. And even if you know you've been seriously injured or killed or your loved one's killed due to that mess up, you still have to prove a link that the thing they did caused the bad outcome.
Of course. A family is learning that in Georgia, you cannot even file a malpractice case without something extra in hand. What is an affidavit of expert, and why does Georgia require one to file?
This one rolls off the tongue for me these days. That's OCGA 911 9.1. Okay, I'm very familiar with that standard, and it's the standard you mentioned, which is you have to file this affidavit of merit. If let's say it's a case involving a surgeon, like we mentioned earlier, you can't get an ER doctor to sign an affidavit of merit if you're filing a lawsuit against a surgeon. You have to find a surgeon who performs the same type of procedures that the surgeon who screwed up was performing. You have to get that same type of expert to sign off on an affidavit to even be able to bring a medical malpractice lawsuit. And sometimes that's easier to do than other cases. And sometimes we have to have difficult conversations with our clients that there's not an expert who agrees that the doctor screwed up, and therefore we don't have the ability to even bring the lawsuit.
How do you begin the process of finding an expert? That's just something that I keep thinking about as we keep mentioning these experts.
Yeah, it's one thing you want to do is you don't want to be trying your hand at a complicated medical malpractice case as a lawyer unless you've got a lot of experience doing it. And so part of that experience is understanding how to seek out, find, and vet the proper experts. Sometimes it's word of mouth. Us lawyers talk I've hired an expert that was on the defense, that was on the opposite side of me on one case. And I thought he did such a dang good job that I hired him on my next case because, I was like, that guy made my case very difficult. There are certain marketing companies that do that. I try to stay away from those by and large when I can, and usually use word of mouth. But even if I go through one of those marketing companies or word of mouth, no matter the circumstances, you have to thoroughly vet your experts to make sure that they're going to be the right fit for your case.
Yep, that totally makes sense. A family that suspects malpractice wants to know how much time they have before the door closes. How does someone have to file a malpractice claim in Georgia?
So almost always the answer to that question is going to be 2 years in Georgia.
Okay.
I believe it's 3 just north of us in South Carolina. They're a little more lenient up there apparently than we are. There are some exceptions to that, but I would never, ever rely on any of those exceptions because a lot of those are very tenuous and require certain proof that you may or may not be able to bring. And so it's a good rule of thumb to say 2 years. Now, for a birth injury case, you actually do have more time. It's told, the statute, for 5 years. And then you have 2 years from that point to bring a birth injury case. So you could actually bring one of those in 7 years. But by and large, if you're an adult, you've got 2 years before the statute of limitations runs, and you do not want to miss that deadline because if you do, your case will be extinguished for forever.
Wow. Okay. A Savannah family suspects something went wrong, but does not know whether they even have a case or what to do first. What is the first step for a Savannah family that suspects malpractice but is not quite sure?
Consult with a medical malpractice lawyer, a seasoned one, right? It's no charge. Everybody that does what I do, and myself included, we work on what's called a contingency fee basis, meaning we only ever ask you to pay us out of a percentage of any recovery you might get. And so consult with a lawyer. Sometimes that lawyer can tell you in a couple of minutes that, hey, it's not a case and here's why. Or the lawyer might say, hey, that's interesting. That's really awful. This happened to you. It does sound like you have something there. Let me go get my expert that I know that does this sort of work and talk to him or her and decide if this is a case or not. And I understand not everybody wants to bring a lawsuit, but if that's something that interests you, definitely consult with a lawyer because it doesn't cost you anything to do so.
Are there ever times where somebody comes to you and you don't even take it to the expert because you're just like, hey, this isn't malpractice?
All the time. I've done enough med mal. It's a lot of what I do. It's probably close to 50% of my cases are medical malpractice. So yeah, if it's a stroke case, I can probably unpack it without an expert. Now, eventually I would still get an expert involved.
Right.
But there are certain types of cases that I've worked on over the years that I don't need an expert to tell me it's not a case. I can unpack that from talking with the family or reviewing the medical records. And I do a lot of research on my own, even before I get to experts. So maybe I haven't worked on this specific set of facts, but I've worked on something similar. I can usually do the extra research myself. I use the same things doctors use, frankly, the same websites they use to look up these things. I look up the same things. And so I go in, I'll do an investigation, I'll do my own research, and only then will I get an expert involved.
It's great that you have so much experience in that. Like the consultation sounds very low risk for a family if they're not quite sure. That covers what makes a Georgia malpractice case worth what it is worth. Last bit is one piece of advice for a listener and how to reach Conn Law Firm. Before we close, give the person listening right now one piece of advice that they can act on today.
One thing I will say is we think that doctors and medical professionals have our backs. And I do believe that when they went to medical school or nursing school, they did want to help people. But oftentimes in the medical industry that we're here about today, there's large corporations that are slashing staff and doing things like that. You have to be your own best advocate. I hear this all the time, that this and that, and no one was there. We were ringing the bell. We were doing this. If you believe there's something wrong, before it gets to someone like me, when something awful happens, the way sometimes to prevent that awful thing from happening is don't trust your doctors and nurses to be on top of things.
Right.
Keep them on their toes. Tell them every single thing that's going on, and make sure if something is worrying you, your body knows sometimes. You have intuition. You need to advocate for yourself so that you don't ever need me. Because my biggest hope is that you don't need me. Because once you
Right.
need me, usually something awful's happened. And so be your own patient advocate.
I think that that's just good life advice too. So I appreciate you for sharing that. If you or a family member was hurt by a medical mistake in Savannah or anywhere across Georgia, call Conn Law Firm at 912-373-8642 or visit andyconn.attorney to talk to Andy Conn directly. The consultation is free. Thanks for listening to Savannah Car and Truck Accident Law with Andy Conn. We will see you on the next episode.